Good afternoon. Welcome to the Education Committee. We do have an hour and a half. Right after this, we go have our K through 12 meet again and finish up that. So we're in the final weeks of our Education Committee. So we're going to try to move diligently but swiftly through these. We're going to jump around just a little bit to make sure those who signed up to speak, we're going to do those bills. But before we begin, everyone sign in so we can take roll. Madam Clerk, would you open up the roll call vote? Okay, everyone that's here signed in. Madam Clerk, take the roll.
Mr. Chairman, you have 17 members present. Mr. Chairman, you have a quorum.
Thank you. Members, anyone have anything you would like to Representative Reedy announce or share?
Thank you, Mr. Chairman. And of course, many of you may have seen them. Stewart County has a lot of students here, high school students that are job shadows. I do have a job shadow, and I'm happy to say that Stewart County is part of House District 74. But Michaela Wallace is in the audience. Michaela, stand up. Let's thank her for being here. And Mr. Chairman, it's I'm hopeful for the future because of the youth that shows up here and gets involved and is interesting in what we do from day to day for the state of Tennessee. Thank you, Mr. Chairman.
Okay, we're glad to have you. Representative Barrett?
Thank you, Mr. Chairman. I also have one of Representative Reedy's constituents. Karina, if you'll stand up, from Stewart County High School. She's been shadowing me today as well.
Representative Jones?
Thank you, Mr. Chairman. Today we found out that first of all, if you were on Ag Day of the Hill, you would have met her. She was one of the FFA from the Eastern region. And today we found out that she is now state president for FFA, Emma Hummer. She's not here with us, but I just wanted to give her a shout out. We're real excited. It's the first one Unicoi County has ever had. So we're very excited.
Wonderful. Wonderful. Representative Bosso?
Thank you, Mr. Chairman. I also am the beneficiary of Representative Reedy's largesse and having Stewart County shadows. And so Brigham Page, please make him feel welcome.
Anyone else want to recognize anyone in the audience or announcement? If not, Chairman Slater, would you lead us in an opening prayer?
Heavenly Father, we come before you today, ready to do your work here in the House. Lord, I pray that you would give us wisdom and understanding as we consider each one of these bills. May they bring honor and glory to you, and may they benefit the people of Tennessee. We pray and ask these things in Jesus' name. Amen.
Thank you very much. Members, we're going to, like I say, jump around a little bit. We're going to finish the calendar from the other day before we get into committee number 2's calendar. And we have some amendments to file, so everybody just hang with us. And if you need to comment on something, get my attention, and I recognize you. Let's hold it to one comment, one follow-up to begin with, to make sure how we're doing on our time, see how much of the committee we can move through. Members, on the original calendar, item number 12 on calendar 1, Representative Greg Martin. Got a motion, a second. Now, this is the one that I was mentioning, Jen subbed, so you would like to take
This
that?
is the one, you're not talking about 2422.
No.
No, the other one, yeah,
1040, House Bill 1043, I'm sorry.
Yeah, but yes, sir, I'd like to take that off notice.
Okay, without objection, House Bill 1043 is off notice. You now recognize on item number 13, HB 2422. You got a motion, a second. Let's see if we got any amendments we need to get in order.
There is an untimely amendment that makes the bill. It is 16661. I can't help it that it was 3 6s.
Okay. We got a motion for consideration, and are you carrying the amendment or?
Yes, sir.
Okay. You're recognized on the amendment. It doesn't, does it rewrite the bill?
Yes, sir.
Okay, then
It makes the bill.
Okay. Legal is always keeping me straight. We got to make a motion to consider this. All those in favor of the amendment? Consideration, please say aye. Aye. Those opposed? The ayes have it, so we are going to consider it. It does rewrite the bill. Members, any objection to adding it to the bill so that we can have proper discussion at one time? Any objection? Hearing none. Okay, we're going to add amendment, and what was amendment number?
1661.
16661.
Those are 3 6s.
So with that objection, we're going to add that amendment to the bill. Any objection? Hearing none. Okay, your bill is now ready to describe.
Thank you, Chairman and Committee. Members, House Bill 2422 is the Hamilton County Testing Reduction Pilot Program that was discussed in yesterday's committee. And I want to thank all of you who shared your concerns to help get this in the right posture. And I especially want to thank Chairman Sapicki for working with me to set a more appropriate standards for an LEA's eligibility. Amendment 16661 requires LEAs to receive an advancing or exemplary district designation to demonstrate a minimum of 40% proficiency rate for students in grades 3 through 5 in English language arts and mathematics, and achieves a chronic absenteeism rate for the district that is below 20%. And additionally, the amendment clarifies that the minimum required testing is for each school year of the pilot program. And out of the committee's respect for the committee's time, I'll conclude my remarks with that. That is the change that happened in the bill with the amendment, and I would appreciate your favorable vote.
Okay, members, if you remember the other day, we had an original discussion on this. It has been amended. Anyone want to make comments or discussion on the bill as properly amended? See no one, and I do appreciate the amendment. We discussed this, make sure that we do keep the standards high if we're going to go down this road for, was it a 2-year pilot?
2 years, that's correct.
Okay, any further discussion, members? If not, we're on House Bill 2422. Any objection to calling the question? Seeing none, all those in favor, Madam Clerk, please put the vote on the board. Thank you. Okay, Madam Clerk, please take the vote.
Mr. Chairman, you have 16 ayes and 1 nay.
Thank you. House Bill 2422 does move out to finance.
And Mr. Chairman, I want to thank you and just say that this is the way government should work. When we have a hiccup, we fix it. So thank you for that.
Thank you. That brings us to item number 11, House Bill 2327. It's, the sponsor was Representative Brock Martin, but I think Representative Hurt's going to carry that for us since Brock had a new baby boy yesterday.
Motion.
You got a motion and a second. Representative Hurt, you are recognized.
Thank you, Mr. Chair, and I'll just start by saying congratulations to the Martin family again. But we do have the amendment that I mentioned yesterday. I went ahead and filed it. It'll be a late filed amendment, but it'll allow us to put it on today if the committee is willing. Amendment number 015610.
So you got a motion to consider. Any objection to the motion? Hearing none. All those let's go ahead in favor of hearing the amendment, please indicate by saying aye. Aye. Opposed? The ayes have it. So the amendment now, is it rewrite the bill or is it just an addition?
It's an addition, but if the committee would allow for simplicity, I would like to add it and then kind of describe the bill as one.
Okay, you got a motion to adopt. Any objection? Hearing none. All those in favor, what was the amendment number again?
015610.
610. Okay, members, we're going to make a motion to 015610, add it to the bill. Any objection to that? Hearing none. All those in favor say aye. Aye. Opposed? Okay, go ahead and describe the bill now.
Thank you, Mr. Chairman. And for clarity, I was wrong on that. I just received information. The amendment does make the bill, so I appreciate moving forward with that. House Bill 2327 is about parent choice and ensuring students with autism spectrum disorder receive the services they so desperately need. More specifically, this bill requires LEAs and public charter schools to allow licensed private pay providers of applied behavior analysis services, or ABA services, access to a student during the school day on school grounds. This is something several counties in Tennessee are already doing and many more wanting to do. This bill puts in a solid framework and guardrails into place to ensure it is done properly and in the best interest of the child. These guardrails are for schools, families, and providers so that services are coordinated, appropriate, and non-disruptive. It requires coordination with the student's IEP team and an execution of a memorandum of understanding between the private pay provider and the LEA or public charter school before services begin. It is important to note that these private pay services are all additional and in no way satisfy requirements of the child's IEP. This bill in no way reduces an LEA's responsibility to provide a child with free and appropriate public education as mandated by the Individuals with Disabilities Education Act, or IDEA. Bottom line is this bill is about parent choice, student access, and collaboration. It protects school systems while ensuring children who need additional support can receive it without unnecessary barriers. And I will mention that I know Chairman Martin and others have worked on this bill pretty consistently in order. I had concerns in subcommittee, and I actually blue lighted the bill because I had a few concerns. And in talking to them, they've addressed those concerns. And moving forward, I believe with the amendment, all the concerns of everybody involved have been taken care of. So with that, Mr. Chair, I'll take any questions.
Okay, members, with that explanation, discussion, Representative Johnson.
Thank you, Mr. Chairman. And that's what I'm curious about, because I haven't circled back. I heard several concerns from special ed supervisors in counties that weren't even, that I don't represent. You know, they were very concerned about how these folks coming in and interacting with the kiddos in the classrooms that they don't have any training to work with and that sort of thing. So I heard a lot of concerns, and I haven't heard back from them with the amendment that they are okay with it. So that's a little bit concerning to me. Are these people going to have background checks since they're working in the schools?
You're recognized.
Thank you, Mr. Chair. I'm not specific about that. The way I understand it, again, I hate to say for sure on that. I don't know. But I will say that my concerns a little bit were to yours was the supervisory ability of or supervising of the individuals that come into schools. I know that was addressed with the amendment in order with the agreement and the memorandum of understanding and all with the private pay. So that was one of my concerns. And the other one was, I think, with being written in the IEP, if it had to be written in the IEP, and then they lost their insurance and things changed, that the school's responsible for it. And I think that was clarified that where they were not, that it was not going to be written in the IEP. So those are a few of my concerns. Maybe I know one was shared with you, but as far as to your question, to be honest, I'm just not positive.
If I may interject, Representative, the legal
Yes.
tell me that they do have to have background checks.
Okay, yeah,
Gotcha.
he pointed that piece out. So that is good, but I still have a whole lot of questions about interacting with the other students that they're not trained to interact with. And the other thing that I heard from folks in the school building is that it requires a space or place or room for them to work. And schools are struggling. They don't have enough rooms with their own folks. So someone else coming in and needing a space to work with a child can be incredibly problematic. And so until I hear back from those superintendents and those supervisors, I'm probably going to have to be a blue light on this bill, even though I like the idea. I'm concerned about how it's going to operate in the system, but thank you.
Thank you. Chairman Spicky?
I'm going to have to agree again with my colleague from Knox County.
It must be the room we're in.
I'm telling you.
Yeah.
Some of the concerns are valid about putting someone in a classroom that the students aren't familiar with, the distraction that could cause to education. I'm in support of the bill today. I think what we need to do is watch this at the next school year when it comes up to see if this gets to be disruptive to the classroom. And if it is, we may have to come back and reconsider what we've done next year when we come back in January, or whoever comes back in January, that to keep an eye on this to make sure it doesn't become a distraction to the classroom. Thank you, Mr. Chairman.
Chairman Slater?
Thank you, Mr. Chairman. And the concern regarding the space is addressed in the legislation, so I don't think that there's a concern there. And I think that this is already taking place in many districts without incident or concern in those districts. As far as students, someone coming in from the outside, a private provider, and then interacting with the other students, that's not even within the purpose of them being on the school grounds. It's to come and to help an individual student. That would be taken care of in the MOU that is the responsibility of the school district to take care of. And so the memorandum of understanding with the school district and the provider can take care of those kind of individual concerns that a school district may have. So I'm very supportive of this legislation. Thank you.
To Representative Barrett.
Thank you, Chairman. Sponsor or co-sponsor, however we need to address you on this. I'm a big proponent of this bill. In fact, I was originally going to sponsor this bill and worked with Representative Martin to allow him to take this and run with it. And with regard to the questions about creating distractions in the classroom, the whole intent of this bill is to reduce distractions in the classroom by providing these students that have these special needs the ability to bring their personal care provider or assistant into the classroom with them. That's actually intended to reduce those distractions from outbursts and different things where they're having a difficult time, where they can be taken out of the mix so that the other students would not be distracted from whatever issue that they're dealing with in the classroom on that particular day or that week. And so this is, I think, vital. I think this is a great step for us as a state to provide these access to these students that have these special needs. And I hope everybody will get on board and pass this through.
Thank you. If there's anybody else, if not, I'm going to go back to Representative Johnson had a follow-up question. Have I overlooked anybody first time? Representative Johnson?
Yes, thank you. Really quickly. ABA is great therapy, and it is important for those kiddos. And like my colleague just said, it often takes place, the place where you do this is in that social situation where you're in a classroom with other kids. ABA privately, there's some, but really it's how a student behaves in that social structure like a classroom. So these folks that are trained only in ABA will be in a classroom with kids that might have different disabilities that don't function the same way and may not have the information about those that a teaching assistant or a special ed teacher would. So that is the concern. I'm a huge fan of ABA therapy and all of that, but I think that I would like to see us incorporated ABA trained folks that are school employees so that they also were familiar with all the other kids and potential disabilities in the classroom. Thank you.
Thank you. Anyone else need to be recognized? If not, any objection to the question being called? Hearing none. Clerk, would you please put the vote on the board? Madam Clerk, call the vote.
Mr. Chairman, you have 18 ayes, 0 nays, and 1 present not voting.
Okay, thank you. House Bill 2327 moves out to calendar and rules. Thank you. Thank you, Representative Hurt. You did a good job on that. Let's now go to item number 17, calendar number 2. I think that completes our calendar 1 that we started the other day. So item number 17, House Bill 2149. Representative Jones, we're going to recognize you on this one. You have a guest speaker, and they drove all the way down from Unicorn County, so we don't want to mess that up again.
Thank you.
Okay, first of all, let's get the bill in order. You got a motion and a second on your bill. You have an amendment?
No, sir. Do I?
We
I
do.
Okay.
Yeah. Let's get 14594. It does say it makes the bill.
Yes, sir, that's correct.
Okay, so got a motion and I got a second. Any objection adding to the bill so we can have full discussion? Hearing no objection, all those in favor say aye. Aye. Opposed? The ayes have it. You are recognized.
Thank you, Mr. Chairman. What this bill does is it deals with some issues that are coming up in our school districts where folks are, some of our students are disenrolling to escape either discipline or truancy issues. And this bill just deals with discipline issues. An LEA or a public charter school may continue a disciplinary investigation of a student who during the investigation withdraws from the LEA or public charter school. If a student withdraws from the LEA or public charter school during the disciplinary investigation, this bill just will will say that the student, when he or she later re-enrolls, the investigation will continue. So we do have our director of schools from Unicoi County, Mr. English, who has dealt with a lot of these issues, and if we could bring him up.
Okay, members, any objection to us going out of session? We're out of session now. Mr. English, where are you? There you are. Come on up to the front table. Right here on the right. We appreciate it. We were up in East Tennessee back in December, and we had this discussion, Mr. Representative Jones, with everyone up there. And so we thought this was an important issue to address. And so we appreciate you driving back down from Unicoi today. You're recognized. If you can squeeze everything in 2 minutes, that'd be helpful.
Yes, sir. I'll be quick. And thank you for your time, Chairman White and the committee. I appreciate your service and commitment to these discussions and the decisions that you make. As the chairman said, I'm director of schools in Unicoi County, have been. This is my 11th year. I also have the privilege to serve on the TOS board as well. So as Representative Jones said, I wanted to, first of all, support House Bill 2149. And I appreciate your consideration. I want to start by saying I fully and wholly believe in parental rights to make decisions that is best for their kids, whether that's homeschool, private school, charter school, public education. I have several friends in our district who homeschool their children. They do it very well. So this conversation for me is not about that population. So I want to be clear about that. It's not an anti-homeschool or choice other than public education for me. But we have two pockets of folks, and what we are seeing, and I believe if you discuss with your superintendents or directors of schools in your areas, they're seeing the same things, is we have a population of folks who are using that right to homeschool only after being in public education throughout the course of the year. This bill addresses discipline, but truancy is also a big issue. What we will see is when we get to October, November, when the truancies pile up on students and we start the process, whether it's a court petition to try to leverage that, they say, no, we're just going to homeschool. And what we have seen this year, we've had 72 students withdraw, disenroll after the start of the school year. All 72 were escaping either discipline or truancy. They left with that. And then what we see that's the real challenge, and again, I hope this conversation just opens up future dialogue and consideration for further bills. They come back a lot of times in the spring, further behind than when they left. And the challenge for us in public education is, yes, we have the right to say, nope, you still have to face the discipline or the attendance. The heart of the matter for educators, though, is we have these students coming back. We know they're further behind. So do we say, nope, you still have to face this? They're going to go right back to homeschool. I'll share just a real quick example. Right outside my office window, and Representative Jones can vouch for this, there's a skate park, a bike park that I can see as I sit at my desk. It is flooded throughout the day of the students who have left under truancy or discipline. I'm not saying at night they're not getting educated, but the concern is we have a population that is slipping through the cracks using the current system. So my hope and encouragement would be that we could have a discussion in the future about holding the accountability. Right now, when students are in public education, we have those measures, we have those mechanisms to hold parents and students accountable. But when they leave, we don't have that. And they stop picking up the phone for us. They stop answering the door as we try to check in. So again, I support House Bill 2149. Happy to answer any questions that you may have of me. Appreciate your time and consideration. Thank you.
Thank you very much. Appreciate that. Representative Johnson?
Thank you, Mr. Chairman. And yeah, I taught emotionally disturbed behavior disorder kiddos, and that was very often the response to when they had broken a rule was, well, we're going to take them out. We're going to homeschool them. I honestly wish they had come back because I'm not convinced they were doing what needed to be done when it comes to homeschool. So I certainly recognize what this is trying to do and appreciate that. But I also think that you made a couple of good points about finding a way to work with these kiddos so that they don't leave in the first part. And I think so much of that has to do with the quote punishments, making sure that the consequences for their action actually has something to do with their behavior.
Yes, ma'am.
And I think if we do that, we won't run into these situations. But I certainly understand where we're trying to go and appreciate. But I think there's a lot of different directions with more conversation that we could go that would make sure kids stay in school and get consequences for their behaviors.
Yes, ma'am.
Thank you. Representative Hakeem?
Thank you, Mr. Chairman. I guess just a little clarity for me. What is it you would like for us to do?
Well, I know we had different iterations of this bill throughout, and sometimes it was kicked back, not legal. I'm familiar with the Supreme Court ruling Pierce versus Society of Sisters, and again, believe in that fundamental right for parents to make the choice. What I would like for us to consider going forward is a little more teeth once the school year starts. If you'll recall, several years ago, we had a date. August. And you had time to declare your intentions for that school year. And to me, the families who are very serious about their kids' education, they've made the decision to homeschool, that date didn't bother them at all. They had made that decision. This is what we're doing. August 1st, August 15 did not matter to them. That date, though, gave us, once the school year started, some teeth and leverage on truancy and discipline issues. That standard has been lowered, and now it's just students flowing in and out at their discretion. And again, a lot of times that discretion is because of truancy or discipline. So that's the concern I have as an educator. It's not about funding. You guys have addressed for public education, funding mechanisms that don't hurt us in voucher and different situations. So I appreciate that. This is just the heart of education of students and realizing we have a large population, not just in Unicoi County, but again, I think if you talk to your directors of schools and superintendents, they'll tell you they're seeing this as well, especially over the last 3 or 4 years. There's been an explosion of that. And so what I would love to see is some accountability, whether it's, I know the original bill, we talked about different tiers. After a certain date of the year, if you weren't in good standing in truancy or discipline, you couldn't just go out. There had to be, some conversation and some authority on the director of schools end to say, no, you're not in good standing. We need to get you back where you need to be. And we have the ability to do that if they're within our system. But once they leave, that's the concern. And we do see them come back, and we can recognize that they're further behind than when they left. And again, I didn't mean to interrupt, but the challenge is when they come back, do we say, well, nope, you've got truancy and discipline issues. They're going to go right back home. So to be honest with you, we go ahead and bring them back in knowing they're behind because we want to make sure they're receiving a quality education.
Thank you very much.
Thank you.
Thank you. Choice, but you got to have accountability.
Yes.
Chairman Sapicki?
And you just said something there to tweak the question is, if they left because of discipline and truancy issues, and if they come back, discipline and truancy issues are going to be enacted upon them, then why would they come back?
Well, to be honest with you, a lot of times, and I've had these conversations with parents, the parents are tired of them being home. They're in their hair, they're in their way, and they send them back to school. I mean, that's just the reality. Now, the discipline side, when they come back, we'll hold true to that, especially depending on the level of discipline. With truancy, we bring them back because we want to have them in classrooms getting what they need.
Thank you.
Yeah, thank you, Chair.
Representative Tim Hicks, then we come to Representative Hurt.
Thank you, Mr. Chairman. Director, thank you for being here
Thank
today.
you.
Let me ask you a question. Like, how much do you see that the student behavior is tied pretty much and pretty close to the parents' behavior? Have you noticed a correlation in between those two? That we need to get down to the bare knuckles here.
99.9999% of the time. I'll leave that little variance, but yes, sir.
So I mean, the point of that is this is a great bill, but evidently there was issues coming through this process with what you really, really, really wanted and needed to do, correct?
Yes, sir.
And the fine representative asked, what can we do? Okay. I mean, a big part of this, and this is probably going down a road to where it's unfortunately going to get worse. I mean, nothing typically ever gets better unless we make a decision here. We want to start making the parents accountable for this is exactly what, and how we do that and what that looks like is two totally different things. But I think that unfortunately, the two are tied extremely close together.
Yes.
Okay. And until you make the parent accountable for the actions of their child and accountable for their actions, then it's going to be extremely hard to do something about this situation. So I just want to put that out there. That's the hard stuff,
Yeah.
but that's where it needs to go. Thanks,
Well,
sir.
well
Thank you,
said.
Director.
What we originally drafted, we're into legal issues, is come August the 1st, if you haven't made plans to homeschool your child, you can't do it into the next semester. But that's where we ran into some legal issues. But yeah, plan ahead. If you're going to homeschool, plan ahead. And if you're a good homeschooler, you're going to do that.
Yes, sir.
Representative Hurt?
Thank you, Mr. Chairman. I just want to kind of build on what the representative said there. We thank you for the legislation and thank you for being here, because last fall I was fortunate enough to be able to, myself and fellow legislators up in Northwest Tennessee, meet with all the directors of schools. And this was one of their top priorities. It was flagged. It was very, very important to them. So I appreciate this step and this discussion. Hopefully we can continue this discussion to find what we can do to slowly narrow this into, whether it be parents accountable, whether, students, wherever we need to take that discussion that we can do legally while still respecting parents' choice and parents' options. So again, I just want to thank for legislation and thank you for being here, because these are important issues and we need to continue the conversation. So hopefully we can prevent it from getting worse, which is inevitable sometimes, but we can kind of get that rolling in the right direction and get some good answers moving forward. So thank you.
Yes, sir. Thank you.
Thank you. Anyone else need to speak on the bill while we're out of session? Mr. English, thank you so much.
I thank you all. And again, thank you for the time. And if I can be helpful going forward next year, whenever, just feel free to reach out. Thank you for your time.
Thank you. Look forward to getting back up in beautiful Unicoi County and seeing you soon. Thank you. We're back in session. Okay, members, we're on House Bill 2149 by Representative Jones. I'll come back to you.
Thank you, Mr. Chairman. I would just state, well, we know this is just one step and hopefully we can continue to work on this as we move forward. So I would appreciate a favorable response. Thank you.
Thank you, Representative Johnson.
Yes, thank you. I want to say there's actually a lot of circumstances with families of why this happens. One thing I saw a lot was actually when the student, because I taught high school, the student might have been actually bullying a parent, or they lived with a grandparent instead of a parent. And a lot of time that was kind of the situation as well. So there's a bigger variety than you would expect. And sometimes the parents are doing everything they can.
Right, a lot of conditions. Anyone else want to speak? If not, any objection to the question being called? Madam Clerk, seeing no objection, Madam Clerk, would you put the vote on the board? Madam Clerk, take the vote.
Mr. Chairman, you have 19 ayes and 0 nays.
Thank you. House Bill 2149 moves out to calendar and rules. Members, we're going to go ahead and take up item 18. Reverend McKenzie has this, so right here, and this will be a short order. So Reverend McKenzie, you are recognized.
Thank you, Mr. Chair. This bill, House Bill 778, was a bill to ask OREA to take a look at our teachers. Well, what we're finding is from a salary structure, they get pretty good increases till they hit that 15-year mark, and then it kind of plateaus. But also we're getting a lot of teachers that go to other jobs about that point and try, or other types of employment. So this was just going to take a look at our public school teachers to see why that is, to get their input. I'm sure money's a part of it, but there's also things that we could do to try to enhance their career. Because after 15 years, they're probably a pretty darn good teacher. The Chairman White and I had a discussion. He has some issues that he would like to ask for some research on as well from OREA. And so what we've agreed to do is that he would include this part into his request to OREA to do kind of more comprehensive look at how we can make our the whole teaching experience enhance and make it better within our budgetary means. So thank you. And with that, I'd like to take Bill 778 off notice.
Thank you. Okay, House Bill 778 is off notice, and Representative McKenzie will follow up on that shortly. Okay, members, let's go back on calendar committee number 2, item number 1, House Bill 2485 by Chairman Haston. You're recognized. You got a motion second. Any amendments? None. Okay, the bill is clean. You're recognized.
Thank you, Mr. Chairman. This bill simply takes us back to defining economically disadvantaged as it was first defined when TISA was put into place. Unfortunately, many students who qualified originally under TISA as economically disadvantaged fell out of qualified status, not because of their economic situation changing, because the definition of what qualified them changed. Originally, Medicaid data, SNAP, and TANF could be used to define economically disadvantaged, but a couple years ago, the Medicaid data part was dropped, meaning a lot of these kids were dropped from qualifying. This bill is not seeking to change the income level that qualifies a student as economically disadvantaged. It just takes us back to the original definition and original intent when TISA was first implemented. And with that, I'd be glad to answer any questions.
Okay, thank you. Representative Johnson.
Thank you so much. So this goes back to before they removed that standard where we lost, so many of our kiddos lost free and reduced lunch. Is that correct?
That is correct.
Thank
And a few of the numbers that we had reported from some counties that had some of the funding that was lost. Meigs County, $420,000. Obion, $308,000. Sevier County, $1 million. Bedford County, $1 million. Roane County, $1 million. Wayne County, $300,000. And Cock County, $600,000 was lost in the last couple of years.
Yeah, and these kiddos were devastated. They no longer qualified, but their income didn't change, as you pointed out. So thank you.
Further discussion. Representative Hurt.
Thank you, Mr. Chairman. And sponsor, I think you and I have asked this question before, but I want to get it on the record and maybe somebody at some point can provide some clarity. First question for you, the fiscal note on this. I'm confused as to how we have this fiscal note when this was figured into the TISA funding from the beginning. And so it's like it's costing us, but it's already in the budget for at least one school year. But then, I mean, I'm just confused on how this works because it has a fiscal note on something that we're already paying for. So I just need maybe somebody somewhere, nobody's been able to give me that answer. So maybe you can help me. You've received some clarity on that.
Chairman Hasty.
I have not, but I will say it's the equivalent to me of you get hired by a business and you sign a contract that you're going to get paid for 12 months out of the year, and then a couple of years into the contract, the boss comes in and says we're only going to pay you for 11 months, and then you convince you get it convinced like, oh, you get that 12 months back, and then they consider it a raise, and it's not. This is a make whole bill to me. So I have not had that clearly defined to me as well. So it's a good point. I appreciate that.
Follow up, Representative.
I guess moving forward, this will go behind the budget. I'm guessing with these kind of numbers that just doesn't make sense because when we passed TISA, that was one of, we were the hold harmless. We were moving forward with this. So I definitely need some clarity because from fiscal or somebody, I'm sure you're pressing for the same thing, but I think we all would ask that for some clarity on how this works to have this kind of fiscal note. But thank you, Mr. Chair.
Thank you. Well said. Well said. Anyone else? Chairman Haston?
I renew my motion.
At that, okay. He's renewed his motion. Any objection to the question? Hearing none, Madam Clerk, put the vote on the board. Okay, Madam Clerk, take the vote.
Mr. Chairman, you have 17 ayes and 2 nays.
Okay, House Bill 2485 moves out to finance. And Representative Hurd, let's follow up on that as it goes to finance. We need to get an answer. Item 2, House Bill 1882 on your calendar by Chairman Slater. You got a motion and a second. Any amendments?
Thank you, Mr. Chairman. No, I'm not going to run an amendment on this.
You're not going to run 15807?
No.
So no amendments, okay. You got a motion second. Go ahead and describe your bill then.
All right, thank you, Mr. Chairman. University boards of trustees are the governing bodies of our state universities. They do several very important things. They appoint the president, they set the operating budget, approve personnel appointments, establish tuition and fee rates, approve contracts, and approve all rules, regulations, curriculum changes, new programs, and degrees of the university. The terms of these boards, of these members, trustees, begin on July 1st of 2025 of each year. Because gubernatorial appointments take place while the General Assembly is not in session, appointees begin serving before being confirmed by a joint resolution of the House and Senate. And as this committee knows, these appointees in the House come to this committee. So what House Bill 1882 does is two things. First, gubernatorial appointments may not serve until they are confirmed. And then secondly, terms begin on February 1st, and existing terms will be extended to accommodate this change. So instead of members being appointed by the governor and beginning their work on boards of trustees and then coming before this body, they would have to come before this body first. And this bill then adjusts their terms, existing terms and new terms, so that it will sync up with their board service. And with that, I stand ready for questions.
Okay, as we open up for questions, let me lead out. My concern, okay, you have the governor's appointment. And when is that going to be made? Is that going to change when the governor makes the appointment?
So this does not mandate or dictate when the governor may make a decision who he or she may appoint. What this does is says that once the governor makes a decision, that those who have been selected must come before the House and the Senate for confirmation before they can actually be installed on the Board of Trustees.
Okay, and the difference is, like right now, once they're appointed, they start serving, and we don't appoint them or confirm them until like February. So during that transition time, do you see any issues there?
No.
We're losing that experience for.
Yeah, no, and the reason I don't see any issues there is because what it does is it syncs up their terms of service so that they will come on at a different time. Their terms of service will be different. It will be February 1st instead of July 1st. Now, there may be some question, and I think perhaps even in sub there was some question about, well, that doesn't sync up with the school year, the fiscal year. But like many members of this body, we serve on boards of directors in other, sometimes for-profits, not-for-profits, that type of thing. And board service doesn't have to sync up with a fiscal year. In fact, I think that there is sometimes some wisdom in being able to come a few months before a new school year begins, as opposed to right on top of a school year. For example, right now, a trustee would begin serving on July the 1st, and that's just a few weeks even before a new school year begins. Now they will begin serving on February 1st. A new board member would begin serving on February 1st, and that would give a few months ramping up to the school year. And so I think that was your question, perhaps, and hopefully I hit it in there somewhere.
Okay. And members, anyone else want to comment? Representative McKenzie?
Thank you, Mr. Chair. I guess I'm confused, and it's probably me. All of that conversation is in my amendment 15807, but I didn't see where that was. I thought he didn't take that up. So maybe this is, yeah, I'm sure I'm confused. So could you explain where this language exists?
Chairman Slater?
Yes, thank you. And thank you for that question. So the language exists in the original language of the bill, which is it's not a, let's see, that drafting code of the original language. It was a clean bill with no amendments. The drafting code on that original language is 010439. And let me just confirm with legal that is correct. But so that is correct. So it's the original language. And Representative, I would point out that the amendment that was filed, but that I'm not running with, would also include the appointees from the speakers of both houses. That was not my original intent. The Senate did put that on, so we'll have to work that out. But that was not my original intent. And the reason for that is that these bodies, the Senate and the House, we elect the speakers. There's representation of the legislative body. The administration, though, there is no representation if we're approving after someone has already been serving. I'd remind members, too, those that have been here for a few years, that there has been an occasion where we have not confirmed one of the governor's appointees. I'd also remind members, regardless of which caucus, there have been opportunity for us to question these trustees, which I think that is vital for us to be able to do, no matter which caucus it may be.
Follow up.
Thank you, Mr. Chair. I mean, and thank you for the clarification, but your second point concerns me. I mean, honestly, as you said, we need to be able to vet all the candidates. In my opinion, I don't see a huge, from my vantage point, I don't see a huge difference between the governor or the speaker of either house. There's still only one caucus represented, and it's good, as you say, to have a dialogue with these folks if you're going to do it prior to them taking office. I would say it will make sense for all of us to come. We are the General Assembly, and I think they should come before us. If it's an issue with them coming late, it should be an issue with all of them coming in late or having served and then being questioned by us. So I would respectfully say I like the Senate's version currently better than this one.
Your follow up.
Thank you, Mr. Chairman. And I would mention, Representative, that currently the situation is where only the governor's appointees come before this body. So that's what we have been doing. That would be quite a substantive change, and perhaps a member would like to take that on. But the bill is before us as it is. Thank you.
Thank you. Anyone else want to speak on this? Chairman Baum.
Thank you, Chairman White. Chairman Slater, my understanding is that this bill just covers the LGIs. And so I thought I would ask whether this is an issue that also needs to be addressed for the UT Systems Board.
Chairman Slater.
Thank you, Mr. Chairman, and thank you for that question. The LGIs, as you know, do have a somewhat different framework than the University of Tennessee. As I was looking at this between sessions this past summer and looked at how trustees were appointed, how they serve between the two different systems, the university system, the University of Tennessee system, is closer to this that I'm proposing than the LGIs are. So this bill only addresses the LGIs.
Representative Hakeem.
Thank you, Mr. Chairman. The more I listen, the more questions I have, and I'm wondering if it would be a benefit to us to have a longer period of time to study what is being asked and how that impacts the system now and going forward. I'm just throwing it out there, Mr. Chairman.
Absolutely. That's your prerogative. I'll come back to you if you want to make that motion, or not, or any further discussion. We do have a THEC here also, if they would like to weigh in. They have signed up. Would you have any desire to? Yeah, I get the thumbs up. They're going to stay in their seat. Okay. Chairman Spickey?
So Chairman Slater, do you want to push forward on a vote on this, or do you want to take more time?
Chairman Slater.
Thank you, Mr. Chairman. No, I think we're ready to vote today. We're getting down toward the end of the calendar. Okay. And once again, this body has experienced this. And so I think I'm ready to take a vote, and hopefully it'll be a favorable vote.
Okay, any further discussion? We're on House Bill 1882? Okay. Any further discussion? Any objection to the question being called? Hearing none, Madam Clerk, put the vote on the board. Everyone voted? Okay, Madam Clerk, take the vote.
Mr. Chairman, you have 12 ayes, 4 nays, and 2 present not voting.
Thank you. House Bill 1882 moves out of the calendar and rules. Let's look at item number 4, House Bill 2167 by. Where's number 3? Oh, did I miss number 3? Okay, item number 3, House Bill 1789 by Representative Reedy.
Thank you, Mr. Chairman. You sure got Representative Barrett excited. Mr. Chairman, there is an amendment that rewrites the bill.
Okay, that amendment is?
15816, sir.
And it does rewrite the bill. So any objection to add it to the bill for discussion? Hearing none, all those in favor of adding 15816 onto House Bill 1789 indicate by saying aye. Aye. Opposed? The ayes have it. Okay, you're on your bill.
Thank you, Mr. Chairman and committee members. Since the Haslam administration, both I and Senator Crow have served on the Governor's Council for Military Veterans and their families. And this bill has come from Senator Crow from past work before I was ever elected to office. And I do want to say thank you to the University of Tennessee as well as Vanderbilt on that. On the bill as it is amendment, the locally governed institutes, Austin Peay State University, East Tennessee State University, Tennessee State University, and Tennessee Tech currently do what's in this legislation. Now, what does this bill do? It requires public institutes of higher education beginning with the 2027-28 academic year to classify a student enrolling in the institute for the first time who is the spouse of a service member who has not resided in the state for at least 1 year as an in-state student for tuition purposes. Requires the service member's spouse to reside in this state while enrolled in the institution, and it adds dependents of active duty military personnel or veterans who reside out of the state to those who are eligible to receive the in-state tuition rate at a public institution of higher education when enrolling for the first time. Requires instead of allows the governing board of each institution to provide the in-state tuition rate to military affiliated individuals. Mr. Chairman, that's time for questions.
Okay, with that explanation, questions of Representative Reedy, Representative Hakeem?
Thank you, Mr. Chairman. Briefly, the spouse, they would be going to school in the state of Tennessee. Is that correct?
Yes, sir, that is correct.
Okay, I thought I heard something else. Thank you.
Further discussion? House Bill 1789. Hearing none, any objection to the question being called? Hearing none, Madam Clerk, put the vote on the board. Everyone voted. House Bill 79 passed and is going to finance. Sorry. Did we get the vote? Okay. Thank you. We did have a majority vote. All right. Item number 4, now we come back to Representative Barrett, HB 2167.
Motion.
You got a motion and a second. Let's get your bill in order.
I do have an amendment, Mr. Chair.
Which one?
014878.
You want to
Motion
go?
on the amendment.
Motion and a second on the amendment, rewrites the bill. Any objection to add the amendment on the bill for proper discussion? Hearing no objection, all those in favor say aye.
Aye.
Opposed? The ayes have it. Okay, you're recognized.
Thank you, Mr. Chairman. As we have students in the audience today, I think it's a good day for them to be here. This bill was brought to me by a University of Tennessee student named Colby Norrod, who served on the Student Government Association there and passed a piece of legislation in cooperation with the administration in Knoxville to create a class holiday on campus at UTK for the election day for general election in November. And Colby decided that he wanted to reach out to the legislature to see if he could make that a statewide application for all institutions of higher learning in the state of Tennessee. And so with his cooperation and in working in tandem with the University of Tennessee representatives, we've come up with this amendment that does make that law applicable to all state universities of higher learning. And with that, I stand ready for questions.
Thank you. With that explanation, questions, Representative Hakeem? And then we go to Chairman Raper.
Thank you, Mr. Chairman, and thank you for bringing this legislation, sir. I guess the only question I might have is that young people, some come from other states. Are they going to be able to vote here? Are they able to put their residence where they are at the university? I didn't know if that's going to create some kind of bottleneck.
Thank you, sir. Thank you for the question. Mr. Chair, am I okay to respond?
Go ahead.
All right, thank you. The purpose of the legislation is designed to encourage our universities to create opportunities on election day for our students to participate, not only in the act of voting itself, but also to take time to volunteer, whether that's with a campaign or also volunteer maybe as a poll watcher or something in the election process. Again, we as a state have a vested interest, I think, to encourage young people to get involved in the election process and in politics as well, to learn more about it. And there's no better civics education than a hands-on experience. So what we've done with this bill, we started out originally with language that created a shall, meaning that we were requiring the universities to give time off for students to do that. We've made it a may in conjunction and cooperation with the folks that were representing the universities. And in the process of changing this language around, we've kind of expanded the intent to not only create those opportunities, but encourage these students to get involved.
Follow up.
Thank you, Mr. Chairman. Is there any clarity as to young people being able to vote? I mean, I hear all the things you're saying. It seems peripheral to the actual voting activity. And what I mean by that, to actually vote. So is there an embargo or anything of that nature that would prevent a young person from using their address at the university to vote in the state of Tennessee?
No, sir. There's nothing in this bill that addresses that. But in particular, first-time voters cannot vote absentee.
Okay.
So this is actually going to assist some of these first-time 18-year-old students, 19-year-old students, their first time to vote, to be able to take that time to go home and vote in person. If they've got a class or a test or something at the university where they are, they're not able to leave campus to go home to do that. And so this bill is creating those opportunities, since they can't vote absentee, for them to be able to leave campus without suffering academically as a result of that.
Okay, just briefly. I'm going to vote for this bill. I think it's moving in the right direction. It's a first step. And at some point, I think the state will allow, I would hope, young people, even if they come from another state, if they use this state as their residence, that they would be able to vote. Thank you, Mr. Chairman.
Thank you. Anyone else? Chairman Raper.
Thank you, Mr. Speaker. I just, number one, I really like the bill and I support it. I just had one point of clarification. You may have mentioned it, but I missed it. Does this apply to public and private, or is it distinguished between the two?
No, sir. This would just be public institutions of higher learning.
Thank you.
Representative Johnson.
Thank you, Mr. Chairman. I like this bill. I also talked to Colby and a couple of other SGA folks. One thing I am curious about though, because like I was a kiddo who lived off campus. If this was an off campus day for me, or we're not going to limit it to that day, right? We'll still have, because UT typically has voting multiple days. So that's not going to eliminate the multiple days. This is just giving one specific designated day that every kid, if they're on campus, can vote.
Well, in the bill itself, we've defined general election to mean a statewide or federal general election held in November of an even numbered year and does not include a municipal or local election, a special election, or an election held outside of the state.
But I'm referring to the early vote. The early
Correct.
vote days are still going to be open on campus. So we're not saying we're limiting campus to one day of voting on election day, but the other days will still be open. I feel like most likely.
You're recognized.
So the intent of the bill is just for election day only, for that day only. We didn't want to muddy the waters too much by expanding this beyond where, when you do that, you've got so many different programs, you've got clinical programs and apprenticeships and different things that are going on, and we've specifically excluded those. So this gets us to where everybody's happy with this one day that we're making sure that these kids have an opportunity to leave campus and go cast their vote.
Super Tuesday, right?
That's right.
Okay. Thank you. Anyone else have a question? I'm going to tell the clerk we need to move in here permanently. We do better in here, I think. We got a lot of bipartisan stuff going on. That's great. Anyone else? We're on Representative Barrett's bill, HB 2167. Further discussion? Any objection to the question? Hearing none, Madam Clerk, put the vote on the board. Okay, Madam Clerk, take the vote.
Mr. Chairman, you have 15 ayes and 0 nays.
Thank you. House Bill 2167 moves out to calendar and rules. All righty. Chairman Spicky, I'm going to recognize you for a second.
Mr. Chairman, I'd like to take out of order House Bill 2533. It's the last one on our calendar.
Okay. Members, if you turn over to the very last one, I think it's number 37.
He's got to get the gavel up.
And that is one that I am carrying for Leader Lambert. We want to go ahead and take this out of order. This is a Department of Education bill. It's a cleanup bill. And, well, Chairman Raper.
Let me just make sure I'm.
It's not. But here, if you want, it should be that.
Okay, perfect. Got it. Let's see. Tell me the bill number again, please.
It's 2533. Let me double check. Yeah, 2533.
Okay. We are now on calendar 37, House Bill 2533. It's already been properly motioned, and at this time, you are recognized, Chairman White.
Thank you, members and Chairman. I'm going to ask to go out of session in a minute, but just let me give you a brief description. This is a cleanup bill from the Department of Education. But
And-
before that, we do want to address an amendment that is on there. And so
That's what I was going to ask you, sir.
Recognize that.
Okay, I have House Amendment 16389. Is that what you have?
That's correct.
It's been properly motioned. I'm going to move to attach. All those in favor, say aye.
Hold on. Where's my amendment? It's back down to me.
I'm sorry. I'm going back to Chairman Speaker. You're recognized.
Thank you. Thank you, members. This is a cleanup bill from the Department of Education, but we did have some conflicts of other legislation that we are working on. House Bill 2364, House Bill 2475, House Bill 2420, House Bill 1740, House Bill 1998, and House Bill 1550 were all in conflict with this bill. This amendment, 16389, removes those conflicts so we can move this bill forward and not affect those other pieces of legislation. So I move for adoption of the amendment.
Thank you for the explanation. We have a move for adoption. Do we have a second? Okay. Are there any questions on the amendment? And Chairman White, you recognized.
I do agree with the amendment. It's a friendly amendment.
No further questions. We are now attaching the amendment to the bill. All those in favor, say aye.
Aye.
And all opposed, record it with the clerk, please. All right. Pardon? Okay, the amendment is adopted. And now we're on the bill itself, and you're recognized again. Let's see. Okay. Chairman Sapiki. Okay. Chairman White, you're recognized on the bill.
Thank you, Chairman Raper. Members, I'm gonna go out, I'm gonna request to go out of session a minute and get the department up here. Like I said, this is a cleanup bill, and I think it has right around 71 sections in it. And they can give us synopsis of me repeating the same thing. But mainly, the Department of Education has a desire to streamline bureaucracy and continually reduce the administrative burden on the schools with the aim of increasing focus on student outcomes. This education omnibus cleanup bill strives to do just that by restructuring the changing statute to improve clarity and make operations easier. So to me, reading all this or going through it, I would like to request we go out of session, bring the department up, and let them explain the bill.
Without objection, we're going out of session. Yeah, the Department of Education, please come forth. Sit in the chairs there, please. If you will, before speaking, if you will recognize your name and title, please. And if you would like to go first, you're recognized.
Emily Cornute, Director of Legislative Affairs, Tennessee Department of Education.
Anna Hall, Legislative Liaison at the Tennessee Department of Education. I'll start with a brief highlight of some of the most substantive pieces of the bill. The changes in the bill include increasing flexibility for funds appropriated and distributed to LEAs and public charter schools for summer programming. So this change will allow districts to use those dollars that are appropriated for summer learning camps throughout the year for 4th grade and 5th grade tutoring. It strengthens the relationship with the department and its administratively attached boards and commissions, including the State Board of Education, the State Textbook Commission, and the Charter Commission by clarifying certain roles and responsibilities and adding a new definition of administratively attached. It cleans up outdated references to local boards of education where the use of LEA is a more appropriate and encompassing term, and also ensuring that throughout the code it includes public charter schools where public charter schools or public charter school governing bodies are and should be included when delegating authority or responsibilities to local entities. It also clarifies the definition of full-time for purposes of paid parental leave, as well as specifying that reimbursement forms from local school districts should be filed with the department within the fiscal year in which the leave is taken. It also has a virtual school enrollment cap. This cap is currently at statute. It's set at 1,500 students, but it doesn't specify whether the cap is per LEA or per school. This language will specify that that cap is per LEA, and that changes moving forward. So any LEA cannot have a total composite enrollment at virtual schools above 1,500. That's the highlights, but we're happy to take any other questions.
Are there any discussion and questions? Yeah. Oh, Representative Johnson, you're recognized.
Thank you, Mr. Chairman. Does this bill terminate the Dyslexia Council?
Yes, Representative Johnson, it does eliminate the Dyslexia Advisory Council. However, it moves those responsibilities to the larger Students with Disabilities Advisory Council that the department is required to convene pursuant to federal law. So we're not doing away at all with the study of dyslexia, just streamlining that into the larger Students with Disabilities Advisory Council.
I just remember it was fairly recently that a whole lot of parents worked really hard on getting that to happen. And so do you know, are the the parents of those kiddos, are they okay with this? Because I haven't heard from them, and I just know how hard they work to get it in place. So I would hate to see this go against what they work so hard
No,
for.
certainly. And we appreciate that. And we've heard from a few people, but candidly, the board has had a hard time getting appointments. And they did a lot of work back when the Tennessee Literacy Success Act was passed. And that was really great work and really important work. But now that we've sort of moved past that, we think it's time to just streamline it. And it will save the state about $40,000 a year to just bring them under the larger Students with Disabilities Advisory Council.
Representative McKenzie.
Thank you, Mr. Chair. There's also a provision here that says that the bill removes present laws requiring that the department annual TISA report to members of the General Assembly include reviews by of TISA by relevant experts, including a cost review and recommendation. Why would we not want to do that? So we've just been around for a couple of years. Why would we not want to have that feedback?
My understanding from the program team is that we have had a hard time finding experts that are qualified under the definition of the statute. Emily, I don't know if you have any additional context to add there.
You're recognized.
Thank you. Yes, Representative. So there's actually a couple of review boards already in statute to review the TISA funding formula. One of those entities, we work with the state board for that review to happen. And then, of course, there is, annual reporting that is still required.
Representative McKenzie.
Thank you, Mr. I think that may be, no disrespect, but a little short. I mean, I think this is important. It's important that when we're dealing with billions and billions of dollars, that we have some kind of external system of checks and balances just from an efficiency standpoint. This should add efficiency. Cutting this out, I think, decreases our actual efficiency and how we're using those dollars. It may be more laborious to find someone, but I would say, I would not remove the requirement at this early stage. It's an evolving process. We got hold harmless. There's all sorts of levers in this TISA funding formula. I just think it would be unwise to remove that this early in the game.
Chairman White.
Oh, thank you. I just wanted to respond to Representative Johnson. You're absolutely correct on dyslexia. Actually, I've got a bill, if we ever get to it this year, on dyslexia. Too many of our young people fall through the cracks in early grades, and we're just going to try to put more attention to that. So that will be coming. I'll show it to you after committee if you'd like to see it. Thank you.
Chairman Spicki.
Thank you very much, Chairman. Can you talk about the State Board of Education? And it looks like that we fought long and hard to make sure that the department and the State Board of Education and the Textbook Commission work together. Are we severing any of those ties in this legislation?
Which one? DOE. You're recognized.
Thank you, Chairman. No, sir, we believe that we're strengthening our relationship with our administratively attached entities through this new definition. It sets clear expectations and an understanding in statute.
Chairman Spicki.
Thank you, Mr. Chairman. Also, it removes the requirement that the Commissioner of the Department of Education approve in-service day plans that are recommended by the local director of schools. Are we okay with that? That we're making sure that we don't have another set of eyes, making sure that that's quality use of our teachers' time?
You're recognized.
Chairman, yes, sir. They will still report that to us. She just will not have to rubber stamp okay those, but we will still be receiving those.
Chairman Spicki.
And then last question, Mr. Chairman, thank you for the latitude here. It also talks about that we are giving add school employee to the list of individuals permitted to conduct principal authorized searches, including searches of vehicles on school property and student or visitor use containers, packages, lockers, or other storage enclosures, as well as physical searches of students based on locker search results or other information deemed reasonable by the principal, provided the employee has a complete training. Reason for that?
You recognize?
Chairman, last year there was a bill that was passed that restricted searches to only SROs and administrators. This will allow, our language says the director of schools to designate additional school employees to conduct those personal and property searches. And they would have to receive training from a licensed attorney prior to conducting any searches.
Thank you, Mr. Chairman.
Are there other questions before we go back in session? We're now back in session. Back to, I've slammed it too hard, huh? So I'm back to Chairman White on the bill, please.
Thank you. With that explanation, I just turn it back over to the committee. Unless there's any further questions.
Are there any questions at all? Yeah, are there any objections to me calling the question? All right, we're now, clerk, if you will put that on the board, please, and all in favor, vote aye, and all opposed, no. Madam Clerk?
Mr. Chairman, you have 13 ayes, 1 nay, and 3 present not voting.
House Bill 2533 moves on to GovOps. All right, tell me.
I recognize you.
Thank you, Mr. Chairman.
We are back in session. You already did that, right? Okay. You recognize.
Mr. Chairman, I'm calling for orders of the day, number 5, please.
Okay. We're now on House Bill 1888 by Representative Stevens. You got a motion and a second. Let's get the bill in order. Any amendments?
Yes, Mr. Chairman, we have 012985.
You got a motion second. Does rewrite the bill. Any objection to add the amendment for proper discussion? Any objections? Hearing none. All those in favor say aye.
Aye.
Opposed? The ayes have it. Your bill is amended. Representative Stevens, you're recognized.
Thank you, Mr. Chairman. This bill came to me from one of our school board members in Rutherford County, but it will authorize the State Board of Education to waive the educator licensure requirement for an individual without a bachelor's degree from an accredited four-year institution if the director of schools or director of a public charter school notifies the local board of education or public charter governing body, but the LEA or public charter school is unable to secure a qualified teacher. And this person would have to have at least 10 years of teaching experience in a category 1, 2, or 3 private school. And there's other requirements that have to be met too that I'm happy to explain, but this would help with the teacher shortage.
Okay, let's start at Chairman Speaker. You have a question first, or Representative Johnson?
Thank you, Mr. Chairman. And there are a lot of things, a lot of people we could hire to help with the teacher shortage, but folks who are coming from a private school, if you have taught in a public school and you've taught in a private school, you know those are two different things. You know, private schools pick who they take and kick anyone out who doesn't follow the rules. So in a public school, you are trained to work with every kind of behavior, every kind of disability, everything that comes your way. You have training in that college to take care of that. But in a private school, very limited to the types of kids that you see and the types of behaviors that you see because they do not tolerate that. So comparing years taught in a private school compared to years taught in a public school, it's like apples to ironing boards. We're not even talking two kinds of fruit here. We are talking two different universes. And so I am adamantly opposed to watering down what folks experience and their education when it comes to a school that takes every single child in a community as compared to a school that picks and chooses who they take and can remove a student for any reason. Those are not backgrounds that can be compared in any way, shape, or form. So I'm adamantly opposed to this legislation.
Thank you, Representative McKenzie.
Thank you, Mr. Chair. This is another, I'm gonna say slap in the face of our teachers. a teacher shortage does not mean dumbing down the process. And I'll say that's what we're doing. If that teacher wants to go back and finish that degree, let him or her go back and finish that degree. This is a profession. This isn't just something that, okay, I've done it at home, or I've done it at a small school. I taught in my Sunday school class, and we go back in. This is there's no monitoring of the standards that they come in with. If you're going to be an engineer, you're an engineer because you've completed the process. If you're going to be a lawyer, I went to law school, but I did not pass the bar. Can you practice in a court? No. But we're letting them practice with our most vulnerable resources, our children. They've not been proven to the standard. There's a standard. You have to have a standard. This dumbs down our teachers, our people that are in charge of our future. Why? We know why we have a shortage. We know why we have a shortage. And so to say we're going to get some people who aren't meeting the standard that we've had for hundreds of years because we don't want to do what it takes to meet the standard, that's not the answer. This is a slippery slope. I'm telling you all, this is a slippery slope that we're on. 2 years. Well, almost. We're going to end up with all of this money that we put in, and we put in some good money. We're not nowhere near there, but we've got some good programs in. These are throwing rocks at what we're doing, at what we're trying to do as a state. Please be on guard for this one.
Thank you for your comments. Representative Stevens, could you address this? To be teaching in a tier 1 or 2 or 3 private school, you are authorized by the Department of Education or the State Board of Education. Can you speak to any of that as far as the standards for the teachers or at this point?
Thank you, Mr. Chairman. That might be a better question for legal, but I'm not sure if the private schools have any oversight for teachers.
Okay, I'll pass. You'd have to look it up. Chairman Slater?
Thank you, Mr. Chairman. And for the sponsor, this waiver does require that a candidate or an applicant must receive training on classroom management. Is that correct?
Thank you, Mr. Chairman. Many of the concerns that were raised by my colleagues are things that are addressed in the bill. And so, yes, it does say that anyone that gets one of these waivers has to agree in writing to complete during their waiver period training on classroom management, serving students with disabilities and English language learners, teacher code of ethics, and requires that person to be assigned a mentor and work with the mentor in accordance with the Board of Education's requirements.
Thank you. And thank you, Mr. Chairman. And you addressed my second question, if there is a mentor that would be assigned, and that is in the legislation. Is that correct?
That is correct.
Thank you, Mr. Chairman.
Thank you. Members, further discussion. We're on House Bill 1888. Representative Johnson.
Throwing them in and then training them is not the answer. This training is not coursework. It's not in your student teaching practicum that you're going to receive. This is not the same, folks. This is not apples to apples in any way, shape, or form.
Thank you. But I would like to throw out, they've been teaching for 10 years, so that's, you're recognized, Representative Johnson. You're recognized.
Private school, and most likely in a classroom of 10 or less, and private schools rarely, if ever, have problems kids because those kids get removed. And that is a fact. They haven't dealt with the kinds of behaviors that you're going to be seeing in a public school, and you have to learn that.
Okay.
And this is factual, folks. I know exactly what it looks like.
Thank you. Representative Barrett.
Thank you, Mr. Chairman. To the sponsor, I noticed on the fiscal note, there's looks like about a couple $100,000 on here, and I didn't get a chance to look at this beforehand. Was this included in the governor's AA by chance?
You recognize?
Thank you, Mr. Chairman. On the amended bill, there is a fiscal note of $119,000 for the first year and $84,500 for the second year. The board apparently needs an employee to help process applications. I'm not sure how many people they expect would come under this waiver, but that's where the fiscal note comes from. I'm not sure if it was included in the AA or not.
Any further question? Okay. That's all I have on my list. Any objection to the question being called on House Bill 1888? Hearing none. No objection. Madam Clerk, put the vote on the board. Madam Clerk, take the vote.
Mr. Chairman, you have 12 ayes, 4 nays, and 2 present not voting.
Thank you. House Bill 1888 moves out to GovOps. Members, all bills remaining will be picked up on roll to next week's calendar. Great job, committee. Thank you very much. We are adjourned. 12.